Hello, and welcome to today's presentation talking about Social Security disability when you're over the age of 55. My name is Kaitlin Fallon Wildoner, and I'm an attorney based in Jacksonville and St. Augustine, Florida. I originally grew up in South Florida. I moved to St. Augustine to attend Flagler College for undergrad, moved to Washington, D.C. to go to law school, and then I moved back down to the St. Augustine, Jacksonville area after passing the Florida bar. I worked for a small firm here shortly after passing the bar, essentially managing the Social Security department there, and then eventually launched Wildoner Law PLLC in September of 2018. In my practice, I help those who are disabled and unable to work fight for the Social Security disability insurance and supplemental security income benefits to which they are entitled. Today, I want to discuss winning your disability case if you are over the age of 55. There is some general information in this webinar that may be helpful for those under 55, but the focus is on claimants who are 55 years of age and older. We will discuss the impact of your age on your disability case, and then at the end, we'll open it to some questions, and I'll also provide my contact information at the end if you would like to reach out with additional questions after the webinar is over. So first, the basic definition of disabled by Social Security. Under Social Security Administration guidelines, you must be disabled and unable to work for a period of at least 12 months in order to receive SSDI or SSI benefits. This does not mean that you cannot apply until you've been unable to work for 12 months, but that you must be expected to be unable to work for at least 12 months in order for your claim to be approved. Generally speaking, the Social Security Administration uses a sequential evaluation process to determine if a claimant is disabled. The process is a series of 5 steps that are followed in the specific order for every adult case. If Social Security finds that an individual is disabled after going through these 5 steps, a favorable decision is issued. If Social Security finds an individual to not be disabled after going through these steps, a denial of benefits will be issued. The first step is whether or not the individual is working above SGA, also known as substantial gainful activity level. At this first step, work activity is considered and reviewed. If an individual is working and his or her earnings exceed substantial gainful activity levels, currently in 2020, that's $1,260 for non-blind individuals. So if an individual is working and in 2020, his or her earnings exceed $1,260 a month for non-blind individuals, they cannot be found to be disabled, and the Social Security adjudicator will not even get to review the medical records. However, if an individual's earnings do not exceed that level, then the adjudicator will move on to the next step, which is where they consider the severity of an individual's impairment. In order to be found disabled, a claimant must have a medically determinable impairment, physical or mental, or a combination of impairments that is both severe and expected to either end in death or last at least 1 year. In order to be considered severe, the impairment must interfere with basic work-related activities. If the impairments are either not severe or they do not meet that duration requirement, then the individual is found not disabled. If the impairments are severe and meet the duration requirement, the adjudicator will move to the next step. That next step is where Social Security determines if the medical condition meets or equals a listing. Social Security maintains a listing of medical criteria that are considered to be so severe that an individual is found to be disabled if his or her impairment meet those criteria. If an individual has an impairment that meets or equals one of the listings and meets that duration requirement we talked about before, he or she will be considered disabled. If an individual does not have an impairment that meets the listing level criteria, then the adjudicator moves to the next step and assesses the individual's residual functional capacity. At that step, step 4, Social Security will review and determine whether, based on your residual functional capacity, if you can return to your past relevant work, which is basically work that you performed in the last 15 years at SGA levels, and you performed the work long enough to learn it. If you can return to your past work, you are found to be not disabled. And if you cannot return to your past work, then the adjudicator moves to step 5, which is to determine whether there are other jobs that you can perform with your residual functional capacity, and also considering your age, education, and past work experience. Social Security will consider those factors to determine whether you can make an adjustment to other work. If you can adjust to other work, you will be found to be not disabled. If you cannot adjust to other work, a favorable decision will be issued. All right. So what does age have to do with it? When making their decision, Social Security reviews the entire medical file. After reviewing the file, SSA will outline what they believe to be your limitations, which results in that residual functional capacity, also known as an RFC. That RFC is assigned to your case and can control a lot about the decisions that are made in your case. As we just discussed, depending on what your RFC and your limitations are, Social Security may then look to your age, education, and past work to see if a finding of disabled can be made. Depending on your age, whether you can return to your past relevant work may play a significant factor in whether you can receive disability benefits or not. This is what this webinar is focused on. For the rest of this webinar, we are largely focused on the RFCs and what it means for individuals who are 55 and older. So the Social Security has grid rules. They're medical vocational guidelines. They are used and they are based only on physical and exertional limitations. If you have mental limitations in addition to physical, they are not considered under the grid rules. The grid rules strictly look at your physical RFC level and match it up with your age, education, and work experience to provide an outcome based on a significant number of occupations that exist. So when Social Security considers your impairments, the agency classifies your RFC as one of these 5 categories: sedentary, light, medium, heavy, and very heavy. Your RFC is based on your conditions and the limitations that Social Security believes are present with your conditions. It is essentially an assessment of what they believe your maximum ability is to do sustained, work-related physical and mental activities on a regular and continuing basis, which means 8 hours a day, 5 days a week, despite the limitations and restrictions that you have resulting from your impairments. At this level is really where having a supportive physician can come into play. If you've got a supportive physician that can put your physical limitations in the record and state why they believe that those limitations exist using your reported limitations and objective testing, that can be very helpful to your claim. While Social Security is not required to use the same restrictions and RFCs that your doctor has placed in the record, they can be particularly persuasive to certain adjudicators within the agency. So to look at a sedentary RFC, that requires lifting of no more than 10 pounds. It may occasionally require you to lift and carry items such as docket files, ledgers, small tools. Sedentary jobs are primarily sitting jobs. Walking and standing may be required occasionally, and sedentary jobs do not require any kind of significant stooping. When we're talking about occasionally, that means it occurs very little, up to 1/3 of the day. In this case, since standing and walking may be required occasionally, generally speaking for sedentary positions, standing and walking should generally total no more than 2 hours in an 8-hour workday, and sitting should generally total about 6 hours in that 8-hour workday. Looking at a light residual functional capacity, it requires lifting no more than 20 pounds occasionally and 10 pounds frequently. And instead of primarily a sitting job, light RFC jobs may require standing and walking up to about 6 hours in an 8-hour day. Medium RFC is a little bit heavier. It may require lifting up to 50 pounds occasionally and frequently lifting up to 25 pounds. Generally, they tend to be standing positions and they may require standing or walking for 6 hours in an 8-hour day, so for most of your day. Generally speaking, it does require your hands and arm use for you to grasp objects, hold them, turn them. Those are usually required in medium type work, and medium work typically requires frequent bending and stooping. So as we mentioned earlier, when it comes to the grid rules, that's where the age comes into play. There are 5 different age categories used in various RFCs. Younger individual is anybody under the age of 50, but it is broken down between 18 and 44 and 45 to 49 occasionally. Closely approaching advanced age is anyone between 50 and 54. You're considered advanced age by Social Security Administration's purposes between 55 and 59, and closely approaching retirement age is age 60 or older. We mentioned that education also comes in. There's 3 different categories of education. There's marginal education, which is a 6th grade education or less. Limited education is generally the 7th to 11th grade if you've completed a grade between 7th and 11th. And then there's the high school graduate or more. That does also include those who graduated high school with a GED. Okay, when we're looking at the grid rules, it also takes into account your past work experience. And so there's 4 different categories of skill level on prior work experience. No prior work experience generally means you don't have any work in the past 15 years that was performed at SGA levels long enough for you to learn it. For example, if in the past 15 years you had a cashier job for 3 months that you did full time, that may be considered past work experience. But if you were the store manager for 3 months, that may not be considered to be past work experience because you may not have performed that store manager role long enough to learn those job duties. Unskilled work typically requires little to no judgment, requires simple duties that can be learned on the job in a short period of time, generally 30 days or less. Semi-skilled work is more complex than unskilled, but a little bit simpler than highly skilled. Semi-skilled jobs typically require more than 30 days to learn, but the actual content of the work may be only a little higher level than unskilled work. Semi-skilled jobs can include jobs that require alertness and close attention. They may require coordination or dexterity, such as if you have to move your hands or feet quickly to do repetitive tasks. And then skilled work requires high levels of judgment and adaptability. It typically involves setting realistic goals or making plans independently. It requires understanding, carrying out, and remembering complex instructions, and usually also requires you to understand abstract ideas and problem solve. Skilled job functions also require work activity in exercising judgment beyond carrying out simple duties, and usually includes some kind of knowledge of principles and processes of an art, science, or applied trade, and then the ability to apply that knowledge in a proper and approved manner. Transferable skills come into play. Skills are most likely to be considered transferable between jobs of the same or lower skill level, and they have to use the same or similar tools, machines, raw materials, products, processes, or services. In order to find that you have transferable skills to other work, if you are 55 and older with a sedentary RFC, you would have to make very little, if any, vocational adjustment in terms of tools, work processes, or industries. And similarly, if you are 60 or older with a light RFC, in order to find that you have transferable skills to other work, you would have to make very little, if any, vocational adjustment in terms of tools, work processes, or industries. Skills cannot be transferable to unskilled work. Okay, so here is, we're going to go through some of the grid rules, just looking at them, so you can kind of understand where you may fit in. If you have a sedentary RFC and you are of advanced age, here is where that all comes into play, looking at the education, your past work, and then whether a finding of disabled is directed under the grid rule alone or not. So I'll leave that up for a moment. Okay, here's a light RFC and advanced stage. Again, you can look and see the education level, previous work experience, and what kind of decision would be directed solely based on the grid rule. And then here's where you'll see a difference in the closely approaching retirement age. So it's not just advanced age, but this is for 60 and older with a medium RFC. You'll see it's tough to be approved with a medium RFC because it means that you're still very physically capable. And here you've got a medium RFC and advanced age. So this is medium RFC and you're between the ages of 55 and 59. It's even tougher. Okay. In addition to those grid rules that we discussed, there are also special medical vocational profiles that serve as exceptions to those grid rules. So you heard me say before that the grid rules just direct certain instances. If you are not disabled according to the grid rule, that does not mean that you're not disabled at all. It just means that you cannot use the grid rule to get to a finding of disability, that there's got to be more than just what's included in the grid rule. So in addition to those grid rules, if you meet the criteria of one of these medical vocational profiles, then you'll be found to be disabled as well. If no profile is met, then we kind of go back to the grid rules that we just discussed. And if none of those are met, then there's additional kind of limitations that we look at and discuss that are beyond the scope of this presentation. But if you do have an attorney assisting you in your claim, that's something that we do day in and day out, is kind of look at all the different avenues for potential success. So one of the medical vocational profiles is arduous, unskilled work. If you've got 35 years or more of either heavy or very heavy work, and you have a severe impairment that prohibits you from performing that past work, and you've got a 6th grade education or less, you don't even go to the grid rules. Based on this profile, you should be found to be disabled. Some examples that I've seen in this are if you are a tile layer, that tends to be heavy or very heavy work. You've done that for the past 40 years. You're now 60, and you recently had an issue with your back that now prevents you from performing that past work, and you've got a 6th grade education, this medical vocational profile would direct a finding of disabled in your case. Okay. No work experience is another medical vocational profile. Commonly, this happens with stay-at-home moms, women or men who were stay-at-home parents. They now have a severe impairment. They don't have any past work because they never worked. They were stay-at-home, and now they're 55 or older. They also don't have their high school degree. They've got an 11th grade education or less. Those individuals can be found to be disabled under this medical vocational profile. Another one is a lifetime commitment to a field of work. If you've got 30 years or more doing work in a particular field, and now you've got severe impairments that prevent that work from being performed, you're now 60 or older, you've got an 11th grade education or less, and you have a past work of either unskilled work or work that was semi-skilled or skilled, but you don't have any transferable skills, this medical vocational profile would fit your criteria and you would be found to be disabled before going to the grid rules. Okay. If you have any questions, please feel free to reach out to me. We did get one, which was whether or not the grid rules are dispositive, and they are not. As I mentioned before, when Social Security is evaluating the claim, they'll look to these medical vocational profiles that we just finished covering at the very end first to see if you qualify into one of those. If not, then they move to the grid rules. And if a grid rule does not direct a finding of disabled, then they go to the next step, which is to see if there are other jobs that you can do, or if the limitations that you have are too severe and prevent you from being able to do any type of job that's available in significant numbers in the national economy. So no, the grid rules are not dispositive. If you were looking back at the slides and you saw a finding of not disabled, for example, if you've got a 20205, you're a high school graduate and you can make a direct entry into skilled work and your past work is unskilled or none, and the grid rule says not disabled. That does not necessarily mean that you cannot win your disability claim. It just means that you cannot use the grid rules as an argument to win your disability claim, but there's got to be more to it to add to the picture. Okay. All right. So I wanted to put up my contact information. I appreciate you spending the time with me today to discuss disability over 55. There's still a lot more that we didn't discuss. So if you do have any questions, please do not hesitate to contact me and my firm. We spend day in and day out fighting on behalf of the disabled to obtain the disability benefits to which they are entitled. You can contact us by telephone. It's up there, 904-657-0579. You can contact us by email, contact@wildonerlaw.com, or through a chatbot on our website, which is wildonerlaw.com. We also try to hold monthly Facebook Lives to answer your questions. Please follow us on Facebook for more information. Again, if you have questions, please reach out. There's a lot more that we did not have the opportunity to discuss in this webinar just for sake of conciseness. There are also probably questions that you have, especially if you are over 55 and you're applying for disability. You've probably heard that it's easier to get, and it is easier if you have someone who kind of knows what they're doing. The Social Security process can be very arduous and complicated, but if you've got somebody on your side who knows what they're doing, they can kind of help point you in the right direction and try to help get your case set up for success. So if you've got questions, please feel free to reach out. I appreciate you spending time with me today. Have a wonderful day.